good morning, afternoon, evening, wherever you are. I am Markus Meyer. I'm an assistant professor of labor law in a corporate context at Maastricht University. And I am indeed the leader of the project on cross-border corporate mobility in Europe. And we do this research now for 4 or 5 years. And we do this in order to map cross-border corporate mobility and then the impact indeed on employees and employee participation. I will also share my screen now, and I will share with you my presentation. I hope this is possible and that you can see my screen now. Right. So in this presentation, I would like to show you a couple of empirical data that we have collected, but I don't expect you to memorize all of these in 10, 15 minutes. So therefore, I will share with you, once I've concluded my presentation, I will share with you the link to the full report, as well as to an article that was open access, published first on the Oxford Business Law blog, so that all the figures that you will see in this presentation, you can look back afterwards. Now, cross-border corporate mobility is what we are tackling in this project, and we want to know where and how cross-border corporate mobility is taking place within the European Union, because this has never been done before. The internal market, we have that since the early 90s, late 80s, early 90s, and we have the cross-border merger directive since 2005, and we will soon have new directives on cross-border conversions, meaning that a company can transfer its seat to another European country, and we will have cross-border divisions also from 2023 onwards. And therefore, we started already a few years ago to map corporate mobility in order to then see what the impact on employee participation is. Now, employee participation in this context is for us information, consultation, and participation at board level, which is often referred to as employee board level representation. In our project so far, we are covering the period of 2000 until the end of last year, but the project is ongoing, so we will publish a new report in a few months then on also 2020 data. But what I will show you today is for the period up until the end of last year. Now, we found the first cases of corporate mobility in 2006. That is right after the enactment of the merger directive. What I will show you today is covering cross-border mergers, meaning two companies from two EU member states, for instance, Portugal and the Netherlands, are merging. A conversion of a company, for instance, a Portuguese company moving to the Netherlands, or a division whereby, for instance, a Portuguese company would split. Part of that company would remain in Portugal and the other half, for instance, would then move to, let's say, Spain, and then you have a cross-border division. And European companies, those are around since 2004. And European companies, of course, are also cross-border in nature, in the sense that a company is then Europeanized from a national company form, for instance, a Portuguese company to a European company. And all of these transactions have an impact on employees, because once a company moves or merges or divides itself or becomes a European company, that has an impact on employees' rights. And therefore, we do this project. Now, we collect our data from official journals of all EU countries, and we enrich these data with company core data in order to find out, well, what type of companies we are dealing with. And we use then for further analysis to see whether or not there's an impact on employees. We first see whether there are employees in these companies. And you will see in a bit in my presentation that quite a few companies do not have employees that engage in these transactions, but those cases where there are employees, of course, we want to check further. We then collect the data on the impact on the basis of the merger plans or other transaction documents in order to see what the impact is indeed. Now, I want to show you this real briefly, because this is the current EU legislative landscape. And those on the left, you see the legislation on seat transfers, so companies moving from one member state to another member state. And the countries in green, there is legislation that allows for these seat transfers, and the countries in red do not have a dedicated legal framework on seat transfers of companies. Now, we do have case law of the European Court of Justice that in the case law of Savage, Cartesio, and lately Holbert, that allows for cross-border seat transfers, given the freedom of establishment of companies, but there is no dedicated framework in place. And you will notice that Portugal, for instance, has a legal framework, but countries, for instance, like the Netherlands or Germany, that have a high volume of transactions do not have such a legal framework. For divisions, which you see on the right, there's even fewer countries in Europe that have a dedicated legal framework in place for cross-border divisions. One of them is Spain, your neighboring country, for those of you who are in Portugal. And in fact, quite a few divisions originate from Spain. Now, turning now to the actual data, what we see is, in fact, that corporate mobility is a phenomenon of the 20th century, and specifically since 2008. So once the implementation deadline of the merger directive has lapsed, we see a tremendous increase in transactions. Then we see a dip in the years 2014, 15, 16 of mobility, and then it increased again. You do see that for 2019, there are fewer cases. That is because cases sometimes take over a year to complete, and therefore we have fewer cases so far reported for 2019, but we expect this number of cases to be also around 1,100 cases for the entire EU. Now, this is the total picture of corporate mobility, and we see, as I said, a stark increase. Now, if we then look further where this corporate mobility is taking place in the European Union, then we see a concentration in few countries. Germany, the Netherlands, and Luxembourg together combine 41% of all cross-border mobility transactions. What does that mean? Well, in fact, these countries are involved either as the recipient country or as the sending country for these transactions. And therefore, let's say the earliest EU member states that are in Central Europe, those countries account for quite a few cases. We do see, however, that due to Brexit, and I will get to that in a second, that cases involving the United Kingdom have sharply increased. And therefore, well, we see more corporate mobility there. For Portugal, we don't find that many cases, in fact. So Portugal does not have that much corporate mobility across borders, but this does not mean, of course, that there is no mobility of workers, for instance, or that there is no assets or M&A transactions, as we would call them, so that there are other types of mergers that are not legal mergers, that those still take place, but legal cross-border mergers across borders are quite rare in countries such as Portugal, but also in the Central Eastern European countries, there are quite fewer cases to be reported. Interesting is also that, for instance, France, which is also one of the bigger EU member states, has much fewer cases than countries like, say, Germany, Luxembourg, and the Netherlands. Now, if we then look further what type of transactions, just to be complete, we see that there are quite a lot of cross-border mergers taking place. And that is also to be expected because we have a legal framework in place already on cross-border mergers. Around 77% of all cases are mergers. Interestingly, we have quite a few cross-border seat transfers, which are here denominated as CBCs. And this is despite the fact that, as I've shown you earlier, there are quite a few countries that do not have a dedicated legal framework on cross-border seat transfers. And if we look, for instance, at the Netherlands and Germany, those two countries have no dedicated legal framework in place for cross-border seat transfers. But despite that, we see quite a few transactions taking place. And this is then a threat to employees because there is, of course, the normal rights that employees have, but there are no systems in place to account for employees' rights when such a cross-border seat transfer is taking place in these countries. There is, of course, the new directive, the Corporate Mobility Directive, coming into force in 2023, but up until then, this is also why we carry on this project. Up until then, we need to be quite vigilant in monitoring what rights might be affected. Also after the Polbot decision 2 years ago, which allows for these transactions, but there's a void in the sense of a legal framework up until 2023, once this framework is applicable. Once the directive will be enacted, the same procedures that apply to mergers will also apply to seat transfers and divisions, and there will be then frameworks in place to make sure that those rights are not lost, in a sense, when the transaction takes place. Right, now moving to employee data, because this is at the heart of this conference. Now, if we look at mergers first, then what we notice is that in quite a lot of the cases, and in orange here are those companies that are being merged into what we call the acquiring company, which is blue. So the merging companies, they will be absorbed by the acquiring company. And what we see is that overall, the merging companies, those that are being absorbed, those are often case small companies, fewer than 50 employees. That does not mean that not quite a lot of employees are affected. In fact, roughly 5 million employees across the European Union are affected by these transactions. But overall, the picture is that the acquiring companies are large, whereas the merging companies are relatively small in size, and oftentimes they don't even have any employees, or 1 to 5 employees, which are often directors of the company itself. The picture is even more stark for seat transfers. So for seat transfers, there is no legal framework in place, but we see that in an overwhelming majority, over 90% of cases, we have very few employees in these transactions. So I said that there is no legal framework in place, but maybe the reassuring part here is that in quite a lot of these cases, the rights of employees are not affected because there are no employees in these transactions. Now, for divisions, there are very few cases. There are around 25 cases throughout the European Union, so we can't draw a lot of conclusions on these cases. But here we have quite big companies that are engaging in those divisions. Those are the companies that we call the original companies, the ones that are, well, existing before the split of the company. And the split off companies, with what we call the recipient companies, those are oftentimes relatively small. And all of these cases, almost all of these cases, originate from Spain, which does have a dedicated legal framework in place. So again, my message earlier was we do not have a legal framework until 2023, but so far the evidence is that not a lot of cases actually concern employees here, also where there is no legal framework covering those employees. Now I want to jump real quick to Brexit, which is, of course, also on the minds of quite a few people in Europe right now. And what we see is that, interestingly, the United Kingdom sees quite an exit of companies already prior to Brexit. I will share with you the report that we have published through the chat. But what you see here is at the top, the entry cases of the United Kingdom, and at the bottom, the exit cases of the United Kingdom. And the UK was a net recipient country for quite a lot of years, from 2008 all the way to, say, 2017. The UK was an entry country, meaning more companies were going to the United Kingdom than exiting the United Kingdom. Now, of course, we see then in the years 2018 and 19 a big difference. When Brexit was announced, all of a sudden, quite a lot of companies are leaving the United Kingdom. And if we then look closer at the month when this was happening, then we see quite correlating with the state of the negotiations that first we had an entry into the United Kingdom, we had more influx. But then once it became clear that maybe a hard Brexit would be a possibility, or that no negotiations would be reached, we see quite a significant wave, in the sense, a different wave. Now we have Corona waves, but then it was all about Brexit waves. We see a wave of companies leaving the United Kingdom, and then another spike around summer of 2019. and we expect another peak of cases now towards the end of the year. Interestingly enough, European companies, SEs, are yellow here in this picture. We see quite a few SEs leaving the United Kingdom around end of 2018, early 2019. So companies already exit the United Kingdom. That also as a message here of my presentation. Now, turning back to employees' rights. So we have an overall picture of company mobility. We have specifically in the UK exit, but then how are rights of employees affected? Now, I told you before that we use employee rights as threshold value. So as basically all those cases where there are no employees, we don't look any further because it doesn't merit the analysis. But cases where there are employees, we select them for further analysis. And well, this is where sorry, I forgot that sheet where the UK companies are going to. It's mostly to Germany. Right, back to the employees' rights. Now, what are now the characteristics with regard to the social impact? Now, we selected those cases for further analysis where there are employees. So what you see here is cases with employees, we selected them, and then we checked the documents whether there is an impact on employees and whether or not a works council was present that was negotiating on behalf of employees. And what we found was that in 57 out of those 64 cases analyzed, there was no impact on employees. So that's good news. Quite a lot of cases, the overwhelming majority, there was no direct impact on employees due to those cross-border mergers that took place. What is still worrisome, and as a researcher, I still want to highlight those cases, are those cases where the impact was not clearly mentioned in the document. It was unclearly stated what is happening, or that there is an impact on employees, and specifically where there is no works council present. And those are these cases that are highlighted here in red. And still 1 out of 6 out of 64 cases, so that is roughly 1 in 6, there are, well, no clear employee representatives present for these negotiations that should take place according to the regulation. And it is unclear what happened to those employees. And I would invite the trade unions and also the employee representatives in these companies to then, well, ask the management for further clarification on these points. This will be clarified in 2023 because the new directive addresses this point that there should be clearer, analyses with regard to the impact on employees and clear specifications in the documents. But so far, this is not the case. And therefore, well, in a sense, the glass is half full. We have quite a lot of cases where there is no impact, but we still find 1 in 6 cases does have an impact, and it is unclear what is being done about it by employee representatives. Then turning to the negotiation bodies. So if there was a mechanism of employee participation in the board prior to the transaction, then due to the before and after principle, these rights should be carried over also after the transaction. And we were checking also these documents, whether or not a negotiation body, so where employee representatives negotiate with management with regard to these rights after the transaction. And we were checking whether or not this was upheld in the documents. And what we see is that the negotiating body was not instated or not applicable, again, in a majority of cases. So in 44, sorry, out of the 62 cases, it was not applicable. And in 5 cases, in fact, a negotiating body was instated, but we still find 13 out of those 62 cases where it was not mentioned or unclear whether or not this negotiating body was installed. And again, here my message is that yes, it goes well in quite a lot of cases, in the majority of cases, but not in all of them. And finally, where these blur negotiations, so on employee participation, took place, we still find 10 cases where it was not mentioned or unclear what the outcome was of the negotiations. So also here, my message would be that it goes well most often, but in quite a few cases, it is unclear what the outcomes are. And therefore, as a researcher, these are the cases that would be most interesting for me, but I think also for practice, it's quite important to see what happens there on the ground in those companies with regard to employee rights after the transaction. that's all for me. So many thanks for your attention.